Eugene has three topics, and one of those topics, cross-examination on previous convictions, I think was the topic that occupied the most time in the deliberations of the task force. It was the most difficult for us to decide, and as a result, of course, there was a very slim majority opinion, and as a result, we have a formulation, I think, in Bill S-33, which will probably make it the most contentious of all the issues dealt with in the bill. Eugene received his Bachelor of Arts degree at Assumption in 1961 and his LLB at Osgoode Hall in 1964. We were called to the bar as classmates in 1966 here in Toronto, and Eugene was in the Crown Attorney's office until 1972, where he was a very active prosecutor. He then, in 1972, became an associate professor of law at the University of Windsor, and after 2 years, he became director of criminal justice in the province of Saskatchewan, and was called to the bar there in 1974. In 1976, we were then again working for the same employer at the Department of Justice, and he is special advisor to the Federal Minister of Justice and Criminal Law. In 1977, he became the Director of Criminal Law Amendments in the department. In 1978, he received one of those rare federal Queen's Counsel designations. In 1981, he became General Counsel, Criminal Law in the Federal Department of Justice. And as well, since 1977, he's been a sessional professor at the University of Ottawa in the Faculty of Law, and particularly in the area of criminal procedure. Eugene has a long list of publications. He's published articles in the Criminal Reports, in the Osgoode Hall Law Journal, and the Criminal Law Quarterly. And most important of all, Eugene has just written a book, which is, I think, just published this week by Canada Law Book, Criminal Pleadings and Practice in Canada. It's just been released in the last few days, and I borrowed his copy.
He gets the toter's fee on it.
I asked Eugene if I could borrow it overnight, and spent the evening reading it, and I must say it is indeed an excellent book, and I recommend it highly to you. I particularly like the format. It is what might be called, or Eugene himself refers to in his preface, as a factum format. That is, it sets out a principle followed by analysis and emphasizes heavily the authorities for each particular proposition. Therefore, it is extremely easy to find cases on a particular point. Now, I think it's only an experienced practitioner who would emphasize such a format, because one becomes very familiar of the difficulty of finding references to a particular point very quickly during a court recess. This book is extremely useful in that format, where you've got to find things quickly. I think it will definitely probably replace Tremier's in the criminal procedure area. So I'd recommend Eugene's Criminal Proceedings and Practice in Canada from Canada Law Book. Indeed, extremely important point, I think, in accomplishment in Eugene's career. Well, I'll turn the mic over to Eugene now.
Thank you, Ken. I hope this isn't one of those computers you were talking about, or ordinateurs. Well, okay. I would never get this admissible in court. I think this morning we found out that Ken had resurrected what I used to call the old, I thought it was outmoded sociological concept of the perfectibility of man, and we're back now to the perfectibility of man vis-a-vis imperfect machines, and I think this is one of those situations. In any event, if there was ever a crime at the ecclesiastical crime at common law called nepotism, as opposed to perhaps simony or something like that, perhaps Ken could be accused of that, because in addition to our class, Frank Armstrong, Dennis O'Connor, Marty Toplitsky, myself as speakers, we obviously have his very capable staff from the Research Institute. I was a little shocked, and now where did Gold go? I can't find him. Oh, there he is over there, the master himself. Used to have Eddie Greenspan for a student at one time. I went through Alan's paper, keeping in mind that he had written an exhaustive treatise on the jury trial, or on the jury process for Vince Del Bono, and a collection of articles that I participated in. His former student Greenspan participated. Now, that article was so exhaustive that the footnotes exceeded the main text itself, and hats off to Alan for that. Yesterday I was astonished when I looked at his article that in fact I had beaten him as far as footnotes went, and I thought perhaps I've beaten Alan in something at last, this great scholar that he is. And then I went ahead and I read Jeff Casey's, and lo and behold, Casey had more footnotes than I had. There's Jeff back there. But then somebody pointed out to me, rightfully so, as only a true academic would, that yours are endnotes, mine are footnotes, and we both share. You're the king of the endnotes, I'm the king of the footnotes. Okay, let's get on with it, perhaps. As Ken has said, enough for anecdotes or war stories. Cross-examination on previous convictions was perhaps the toughest topic that we did tackle. I'm not sure it's going to prove as controversial as he said, because there's been some modifications from the original positions. You'll have to remember the distinctions at common law, and Graham's here to tell us the history because he's the legal historian here. But there was a distinction between incompetency of a witness to testify, that is, you were disqualified, convicted of any form of treason, felony, and those misdemeanors involving a lie, then you couldn't testify. In addition, there was a very practical observation that if you were convicted of felonies, you were either hanged or you were transported or outlawed, sent to the colonies. We never experienced that. Very little in Canada, Bobby. We in fact sent most of them originally to the United States, and after the Revolution they went to Australia, and we've seen the consequences in the Thornbirds. In any event, we had things like that. You were interested in an action, then you couldn't testify. So we really didn't have this concept at common law because these people didn't testify. We still had the relics or vestiges of compurgation. You attacked witnesses who weren't interested in the proceedings, who hadn't been convicted. You still could attack them generally in cross-examination, or by calling people as to their general reputation as to honesty in the community. So we have a lot of that old case law. But eventually, accused not being able to testify until 1893 in Canada, 1898 in England. England came after us for a change, Graham. In any event, we had to do something about what do you do about accused who testify with previous records? Well, we duplicated what in essence is the present section. We said that the jury is entitled to know the full background of an accused person. In fact, any person, any witness. So you can put any previous conviction to that particular witness. That wasn't so, however, and that is based, I guess, on what the sociologists or social scientists call the empirical assumption that character is indivisible. We heard that expression yesterday, and I think that was the basis for it. So you're entitled to know the person's full character. Part of that character, part of what you stand for are your previous convictions. Somehow that distracts from your character. England was a little fairer. At one time, of course, since you couldn't testify, the record never came out. Crown couldn't, character evidence or bad man rule, the previous conduct of an accused could not come out. So when they finally permitted an accused, what could you do with previous convictions? The solution is found on page 3 of my paper. They did, in fact, allow it, but only in very limited situations. Situations such as where, in fact, it's directly admissible, similar fact evidence. Where the accused, in fact, calls evidence of good character. He says, I belong to the same club as Mr. Justice Norman Scott, Mr. Justice Robert Burke, or something like that. So somehow he puts his good character in issue. Or where he, in fact, casts imputations on the character of the prosecutor or testifies against a co-accused. So somehow there's a justifying basis, there's something here that says it's only fair because he's done it himself. He's opened the issue by either calling direct evidence of good character, he's attacked the prosecution witness, or he's attacked a co-accused. So that's been the basic approach, and that's what we struggled over during several months of the task force. We ended up, as Ken would say, the proverbial very clear vote of 6-5 to 1 on this particular issue. Now, in England, I should say before I leave that, they have in practice, and some of us are practicing lawyers, well, maybe I'm a hybrid of a part academic, as maybe Alan is, that there is this concept of throwing away your shield. Some people call it the Gardol shield, but only Canadians, Bob. And this is that the judge will literally warn you that you've gone far enough. Yes, you can say, as Ken did in his article on character evidence in the Osgoode Hall Law Journal, and I think Mr. Justice Martin picked it up in McNamara. You can say things like, you live here, you've been working so long here, you have so many children, you're still with your wife. That's not given good character evidence. So you're not past that threshold. Monique Guébert raised that with me several weeks ago during the Senate committee hearings. So McNamara, I think, stands for that proposition. That's really not, you're entitled to do that. You don't throw away your so-called shield. Judges usually tip counsel off. They cough very loudly and wave their finger. You're about to lose that protection in England. Okay, what did we in fact come up with? Well, I think we decided that, look, after all, previous conduct is collateral. It's not directly an issue. Judges have to instruct the jury, the classic instruction that your previous conviction is admissible only to impeach credibility and not to show guilt or propensity to engage in criminal activity. Now, some people also laugh. The English have had shadow juries, mock juries following this, and most of them will tell you that's very determinative of guilt or innocence, especially when you get something very close to the man. You haven't got similar fact evidence. You can't lead it directly as part of the Crown's case, but you've got 10 previous convictions for false pretense. He's up there being tried for false pretense, and you cross-examine him on this, going only to credibility. Very difficult for a jury to make that subtle distinction. So that's been questioned. Now, we decided that jurors cannot make those distinctions, that they do rise to their prejudice. They do use, at times, previous convictions for all purposes and not only impeachment purposes. So we rejected, and when we say we, I'm talking about, in fact, the Federal Provincial Task Force. The Federal Provincial Task Force then said, okay, as a general rule, previous findings of criminal conduct are inadmissible unless, this is on page 8 of the paper, the finding is in respect of guilt, is in respect of a crime of dishonesty. Okay, the justification here then is that the witness is proffering himself as an honest witness, a believable witness. If therefore that witness has been convicted of crimes involving dishonesty, somehow that should reflect upon his believability at this time. The jury is entitled to know that background in assessing honesty, credibility, worthiness, or whatever you want to say about this. Okay, now, one thing that the task force perpetuated was the Canadian approach that you treat the accused as any other witness. But in addition, they went further and they said, however, now, the prosecutor is entitled, as of right, if you have this previous crime of dishonesty, but in addition, the judge can allow that conviction where it's of substantial relevance to the credibility of the witness. I had great difficulty against that. I didn't vote for that. I don't know if I was the 5 or the 1 or where. That requires a voir dire. Is it the crime itself? Is it the factual basis for the crime? I couldn't see that operating on a day-to-day trial administration basis. So that's what we were left with. We obviously had rejected the Law Reform Commission approach, which is found on page 7, which, as the Law Reform Commission tends to do, Patrick, or is he still here? They did it backwards. 64-2 obviously is the general rule. The general rule is you cannot get into previous convictions unless the accused has introduced his character evidence, first introduced evidence solely for the purpose of supporting his credibility, some kind of character evidence. Then he throws away his shield or protection. And then there was a limitation as to 5 years from release from confinement or crime, whichever is the later. Mr. Justice Latimer in dissent would have rejected that approach. He was then vice chairman of the commission. Mr. Justice Patrick Hart was chairman. Uniformity conference then in Whitehorse with such heavyweights, and I say that very respectfully as your former student Eddie Greenspan being there and others, compromised, of course. The Crowns were saying, my gosh, what are you doing to us? Mr. Justice Murray very strongly felt, I reproduced this on page 9, he says, well, somebody that passes a bad check, steals something, those crimes go in if they testify, but not, he says, convicted hired assassins, convicted drug dealers, convicted pimps. He didn't like pimps for some reason. Anyways, he said, these people are certainly less credible than somebody who passes a bad check. So he didn't like it. He said, let's continue the practice we've had since 1893. Well, uniformity rejected that approach, although I remember a defense counsel from Quebec arguing that we should continue that approach. From Mr. Morris Fish's office, in fact. In any event, what uniformity said then was, okay, we'll compromise. We'll let the judge make a comment plus the prosecutor on a failure to testify, another issue, but as part of the compromise for taking away our absolute right to cross-examine on all previous convictions. This was a so-called trade-off or compromise the Canadian way. Some people question whether or not there was an interrelation between the two subjects, but at least the commissioners thought so. So, on page, bottom of page 9, going over to 10, cross-examination would have been permitted again. A compromise between sort of the English and American approach. Admissible to show that he's guilty, similar fact evidence, put the character and issue directly relevant, given evidence against a co-accused, conviction is one for perjury or given contradictory evidence, or involving an element of fraud, or dishonesty, if you want to put it that way, fraud within the meaning of the Olin case. I should say here it's a blending of 1F of the English approach and the American approach. For the American approach, you should read Mr. Justice Patrick Hart's very excellent article in the Studies in Canadian Criminal Evidence put out by Salhaney and Carter in the early 70s. Very good article. The American approach basically says there is a logical relationship, a relevance between crimes of either mendacity, where there's a direct lie and you're telling the truth now or not when you're testifying, or dishonesty. We opted for the broader concept of dishonesty. Those were the two American approaches. Okay, what do we have then in the Canada Evidence Act? Canada Evidence Act then says we're now into section 123. It distinguishes, it rejected the approach of the task force that witnesses are no different from, non-accused witnesses are no different from accused witnesses. It says nonsense. The liberty of an accused is at stake. So, it permits continuation of Section 12 of the present Canada Evidence Act. A witness may be questioned by the court or any adverse party as to whether he has been discharged or convicted in Canada or elsewhere, that's Stratton, of an offense. Now, again, it will continue, that's up to the defense counsel, it's up to the prosecutor, non-accused witnesses. 2, and there's an interrelationship between character. If you put character in issue directly, to some extent, previous sections say the prosecutor can put it in addition to credibility for all purposes. A witness who is an accused in proceedings shall not be questioned, general rule, unless, or the adverse party. Fairly important because in the co-accused situation it's cut down as well. Unless A, the evidence is otherwise admissible, similar fact evidence. Given evidence against a co-accused, always been the rule in England. 3, and maybe there should have been some sections here. On all charges or convictions for perjury, discharges, that's obviously 662.1 sub 1, or convicted of perjury or given contradictory evidence, or whether within 7 years prior to the date of the present charge, there's a time cutoff, he has been discharged or convicted in Canada or elsewhere of a crime that involves fraud as an element. Okay, so again, the concept of fraud would probably include certainly fraud, false pretense, all offenses like that, probably theft because it's fraudulently and without color of right. But impaired driving, assaults, possession of drugs, the vast majority of cases are gone. So by this, in any event, in fact, by this approach, the absolute right of the Crown to cross-examine on all previous convictions of accused is gone, and probably justifiably so. But some prosecutors still question that. Okay, unless there are any questions from senior counsels, the like of Messrs. Burke and Scott, or John Lang from Kitchener, or Bill Salem, more classmates from Windsor, I'll get on to the next part of comment, and Alan Gold doesn't even have a question, I'm surprised. Comment on failure to testify. Oh, I should say, Mr. Gold argued this Titus case in the Supreme Court of Canada, where Mr. Justice Osler, in his ultimate fairness, as he always is, refused to let a Crown witness be cross-examined on an outstanding murder charge, hadn't yet been convicted. Refused to allow that. Poor Alan lost in the Court of Appeal, but he won in the Supreme Court. Oh, you didn't take it. You would have won in the Court of Appeal. Won it finally, and I think it went without reason, that when you're dealing with non-accused, you're entitled to probe much more. The other interesting point, there's about 2 lines, and maybe again it's a reflection of his advocacy. Mr. Judgment or Mr. Justice Ritchie, at the end of the Crown's case, if you're non-suited on the greater offense, Mr. Justice Ritchie said the previous case law was wrong. You have to direct the jury to acquit immediately. Although he then went on to say, in any event, the judge did what he had to do at the end of the case, so there was no substantial miscarriage on this. So another feather in Mr. Gold's otherwise illustrious cap. Comment on failure to testify. I'm engendering business for you. Sections 94, 95. Okay, keep in mind here the present law in Canada is reflected in 4.5 of the Canada Evidence Act. No comment by the prosecutor or the judge. Now keep in comment, Normie, you did this to Henry Bull, I think, or maybe Humphrey did it to your client in one of those big jewelry cases in the early 60s. Co-accused can comment on the failure of a who testifies or who doesn't testify on the failure of the other. What did he have to hide? Why didn't he testify? My client went up there and was subject to Mr. Bull's rigorous cross-examination, and of course Normie's client went down the tubes. See, war stories, we all have them, don't we? Okay, in any event, should contrast that with Mother England. In England, the judge may make a comment. And Dr. Tollefson back there, in getting his PhD or his SJD in this area at Oxford, studying under Sir Rupert Cross, did some statistical analysis of what happens in England with respect to accused who testify and not here. It's reproduced in the Task Force Report on Evidence. It shows basically that in England, and I think the studies that Ed did indicated about 98% of the accused in England testify, whereas in Western Canada it was only in the 30s. I would have thought in Ontario it might be a little bit higher than that. And the conclusion was, of course, somewhat related to Section 12 because you're subject to being cross-examined. But the other thing is the encouragement literally is part of this trade-off by the English judge to testify, lest he make an adverse comment when you don't testify. So it's almost understood because you have this protection from cross-examination on previous records that, in fact, you're entitled to testify. And one thing, I guess, maybe an important thing that I didn't stress, and I'm now in a different topic, but my mind does jump around a bit. We did not accept the English premise that just because you vigorously cross-examine a Crown witness, you put your character in evidence, and therefore you can be cross-examined. We felt, as part of the North American tradition, you're entitled to attack all Crown witnesses without exposing yourself to the risk of cross-examination on previous convictions. So we did not adopt that English practice. Okay, so in England at least there's encouragement to testify. What did we decide? Look at page 16 as we go through the evolution of this bill. Law Reform Commission, Messrs. Hart, Latimer, and others would have allowed everybody to comment. Again, strong encouragement to testify. Judge, prosecutor, and defense counsel. What about the charter? I don't know. But then they would have cut down on the right to cross-examine. So that was very wide, very sweeping. Now, the task force then had another war story in mind when we went into the task force proposal. Task force said, all right, we won't let the adverse comment be made either by the judge or the prosecutor, but we think the jury should know that the accused had a right to testify. Keep in mind the Vizo case in the Supreme Court of Canada. Mr. Vizo was involved in a bank robbery, either in Quebec City or Montreal. The bank robbery, it was a robbery in a restaurant. There was a shootout, some people were killed. He called l'alibi. You know what that is? Yeah, it's alibi in French. So in any event, he's really up. He went to Queens. He never made it quite to Ottawa. In any event, the trial judge, the accused didn't testify, but he called other alibi witnesses. Trial judge expressly instructed the jury they were not to take into consideration the failure of the accused to testify, could not draw no adverse inference therefrom. Reversed in the Supreme Court of Canada, Supreme Court of Canada says, yes, you're to keep them in ignorance of the right of the accused to testify, but you can't go the other step and affirmatively say that you can't take that. You can, in fact, take the failure of the accused to testify into consideration. Mr. Murphy up in Barrie, somewhere up the way, a Crown attorney, tells of his little anecdote or war story that happened to him. He had one of those open and shut cases, 7 witnesses, confession to the police, fingerprints, the whole thing. One of those things you couldn't lose in a million years, as only the prosecutors know. And of course, after 8, 9, 10 hours, the jury acquitted. So this is, I guess, before the Edson Haynes Amendment about not talking to the jurors. Murphy put that Irish strong arm on the foreman and said, what happened? What happened? What's this thing? Why did you let this guy go? And he said, well, Mr. Murphy, we took the straw vote. It was 12-0 to convict because the evidence was overwhelming after all. But then somebody said, finally, wait a minute. Why didn't the Crown call the accused as a witness? And we finally decided, Mr. Murphy, you were totally unfair and we couldn't convict in those circumstances. Now, as part of that then, there was an attempt to inform the jury, to take them out of their ignorance, to say, look, in fact, the accused can testify, but not to tell them what they could do with it. Okay, so you see that at the bottom, a standard word recipe, a formula, including in the situation where there's a legal onus. Now, law reform, or the uniformity commissioners then, in fact, would have adhered to that, but they would have changed it, as I said earlier. They would have allowed the Crown as well as the judge to make comment on the failure of the accused to testify. Now, turning to page 18 then, you see finally in section 94 that that has been rejected. Okay? 4 basically duplicates, reproduces the 94, section 94, reproduces 4-5. Failure of the accused or spouse to testify, not be made subject of comment. And of course, the case law says adverse comment. McConnell and Beer more or less distinguishing Bijatu and the previous cases. On the other hand, then we see perpetuated in here the comment. What type of a comment? Now, some people have criticized the comment. Two avenues of thought here. Prosecutors are saying, my gosh, you're overruling implicitly Vezo, which allows them to draw an adverse inference from failure to comment. That's in sub 3 when you say he is free to remain silent if he chooses to do so. Although the accused has the right to testify on his own behalf, the law imposes no obligation on him to do so. He is free to remain silent if he so chooses. In this case, he's chosen not to testify. You point out the obvious, but you tell him. Now, in saying the law imposes no obligation on him to do so, is that telling the jury they're not to draw any adverse inference? So some of the prosecutors don't like it. Some of the defense counsel, on the other hand, equally don't like it. They think now you're telling them that they have the right to draw that inference. You're pointing it out. You're highlighting that fact, and somehow it violates that common law right against self-incrimination, which Dr. Ratushny has proved as Marc and Solomon. Remember Joe Marc and A.B. Solomon? Supreme Court of Canada case? In any event, that says there was no such common law doctrine. Okay, I know you guys know them. I want to raise a point to keep people awake, as Frank Armstrong did to me, and I want to do it with Ed Tollefson, and I should have raised it before, Ed. You've duplicated in the bill the so-called Bathurst direction as to where there's an onus on the accused. And I questioned, after doing several push-ups this morning to wake myself up, because John Power told me I have to do them to keep in shape or keep up with them, as to whether or not in 95.1 the word should be really a legal burden as opposed to an evidential burden, because in fact the evidential burden is only to make it a viable issue. The legal burden is a true reverse on a balance. And here in the bill we have, am I right that it should refer to a legal burden as opposed to an evidential burden? Okay, it will be changed. Tollefson's the draftsman. He'll change it. Strike that out. Monique will take that now, and I'm sure, and she'll change it in committee. In relation to 95.1, where there is this, when they say the so-called, he runs the risk, the accused is not required to testify, but the burden of producing evidence is on him, and if he does not testify, he runs the risk of not being able to defend the case or charges against him. That's in relation to a legal burden and not evidential burden, so Section 95 of your Act, 95.1, should be changed, and it will obviously then be changed. Okay, so that's, again, part of the compromise. Retains 4.5 of the Canada Evidence Act, but informs the jury of the right of the accused to testify. Corroboration, last subject matter then. Corroboration is in 125 of the Code. You all know the present law, drastically reduced by Vetrovic, magnificent judgment, another one by Mr. Justice Dixon, who's now coming more towards the middle, Alan. You may not like that, but he basically says that common law corroboration has no present validity in Canada. You may look for confirmatory evidence in relation to accomplices, sex case, certain sex cases not covered by the sex bill. The sex bill takes it out in relation to specified offenses and such. It's gone. What about statutory corroboration? Well, statutory corroboration, you have to remember, unlike previously for rape and some of those others, it now simply says corroboration is required. Will it be corroboration in the Vetrovic sense, or will it continue to be that in the Baskerville sense? I think with recent case law in the Supreme Court of Canada, Workington, cases like that, that probably it's moving more towards looking for confirmatory evidence. Doesn't have to be evidence that in fact is totally independent of the declarant or the witness, and it doesn't necessarily in itself have to implicate the accused. It just somehow has to confirm that evidence. So what we've tried to do then overall in relation to these three areas, we've tried to cut down on the absolute right of the Crown to cross-examine on all convictions, but we didn't want to take it away, period. We compromised a little bit between the American approach. We allow cross-examination on previous convictions involving dishonesty, but take most of the English approach, except for where you attack a Crown witness. Then we perpetuate no comment by Crown or judge, unlike Mother England with the judge, but we tell the judge he has to tell the jury the accused has the right to testify. In corroboration, basically, maybe I should go on one step in 125 to point out, before I'm trying to speed it up, I hope I'm not quite as fast as Mr. Nagro was yesterday. Reminded me of myself in law school days. They used to call me machine gun. Look at page 125 at the end. Law Reform Commission recommendation, section 88, I think, would have abolished corroboration outright. No corroboration. Corroboration no longer required, period. It was as simple as that. We said it can't be as simple as that. Okay, the general rule then is corroboration is not required, 125.1. Then, however, it goes on to say the judge shall, maybe it should be may, but that's another question, a may meaning a shall, instruct the trier of fact on the special need for caution in any case where the court considers that an instruction is necessary. But again, this is only the need for caution, somewhat like Vetrovic, but not corroboration. Be careful about this witness is testimony. This is a very unreliable witness, tainted, prostitute, drug addict, or whatever, testifying for the Crown, not within the subsequent categories. And shall in every case give instruction with respect to A, the evidence of a witness who has testified without taking an oath or making a solemn affirmation. Now, implicit in that is now you can have a conviction on unsworn evidence. Now, some people will question that undoubtedly, as I did, but I lost in the end result. Some people will say you have to get past that initial hurdle of having either oath evidence or affirmation evidence before you can convict. Other people say I'm a dinosaur, I'm of the other age, and that in fact children's evidence is often far more cogent than that of adults. They remember much more in detail. Let the jury be instructed of the special need, but you don't necessarily have to have evidence under oath or affirmation. So that's the dispute, the policy dispute involved in 2A. B, the evidence of a witness who in the opinion of the court would be an accomplice continues that, but again, and maybe it overrules Vetrovic and gives you more, speaking of the defense counsel, than Vetrovic does. Judge shall tell the jury of the special need for caution in that particular case. C, the evidence of a witness who was proved to have been convicted of perjury, maybe we should include in there, or the giving of contradictory evidence. Automatic in that particular case, previous conviction for perjury. Or D, a case of treason, high treason. That's because it might be a government case where they're really trying to get somebody. You want more evidence. It's always been a political justification in those cases. It's really a prosecution of the state against the poor individual accused in those cases. Or perjury. Perjury is a one-on-one. If you're going to convict somebody of perjury on a one-on-one, there should be a special need for caution. So we didn't go all the way. We've been accused in the last few days of being fairly cautious, and I agree. And I think here we were cautious to safeguard certain rights for the accused. So we didn't accept the Law Reform Commission recommendation of total abolition of corroboration and any comment. Hopefully in this area it's made the law a little bit simpler and more accessible to the average lawyer, judge, and even average Canadian. Those are my comments, Robert.
Thank you, Eugene. I think Eugene is well on his way to becoming a national figure in the area of criminal practice. The next speaker, Graham Parker, Professor Graham Parker, will deal with judicial notice. I don't have a CV on Professor Parker, but I think many of you are familiar with his writings. He's a professor of law at Osgoode Hall Law School at York University, and he is certainly well known in the area of criminal law. Professor?
Thank you, Ken. I suppose one could look upon this as light relief, really, after some of the other stuff. I start off talking about judicial notice by looking at all those silly cases that you remember from law school about the fact that rain falls down and Toronto's in Ontario and dogs bite and whiskey makes you drunk and all those other silly things. I thought that probably the most instructive example of that is not a true story, but a potentially true story, that the prosecution is opening its case and it's describing to the judge sitting alone that the accused allegedly stole 3 items, that he stole a Polaroid camera, Model 1A, and the judge said, "What's that?" And the prosecutor explained. And then he said, secondly, he stole a Betamax Model 120-B. The judge said, "What's a Betamax?" And the prosecutor explained again. And then thirdly, he said, "Your Honor, the accused allegedly stole a S&M brand inflatable human figure, deluxe model." And the judge said, "Oh yes, the deluxe model is the one with pubic hair." Now, one of the things you'll notice, and I point out in this paper, is that a lot of those silly cases are very old, and I suggest that what that implies is that the judiciary has changed an awful lot. And I point out that the notion of the judge sort of being the 3 monkeys who doesn't see, hear, or speak any evil has gone. The idea of the judge being completely cut off from the real world is behind us now. And I think that is an important factor which I'll return to when I have to look at legislative facts, so-called, for a bit. But let me first sort of do the sort of tombstone information that you'd want to know, namely that Section 18, of course, is mandatory judicial notice, and Section 19 is discretionary judicial notice. That Section 18, for a start, looks at the statutory law and says that a judge shall take judicial notice of that. That statutory law includes colonial law, meaning the law that existed prior to Confederation or prior to self-government, or whatever it might be. And then subsection C of 18 refers to Acts of Parliament of the United Kingdom, and that should not cause any trouble, but I would just warn people, I suppose partly because of my penchant for legal history, that they could well get into very serious troubles of reception. And Mr. Cote from Alberta, of course, has written extensively on the question of reception, what laws sort of came across in the ships to Upper Canada or whichever particular province it is. So that could be a potential problem. I think the important thing is, in relation to Section 18, is subsection D, because D has widened somewhat the subordinate legislation which shall be judicially noticed. And you'll see in D there a very wide range, that it includes regulations, orders in council, proclamations, bylaws, and rules of pleading, practice, or procedure, with the qualification that it is to be published in the Canada Gazette. Just as an aside, I point out that that particular mandatory judicial notice is quite important for those cases largely spawned by Judge O'Hoan from Nova Scotia about the rather evanescent defense of mistake as opposed to ignorance in Section 19 of the Code, mistake of law. And that what we have here is a guarantee, at least on paper, that there'll be more thorough publication. We'll yet to see if that is likely to apply in fact. Now, Section 18E is an important one because Section 18E is in fact a mandatory one without quite being a mandatory one. Because Section E says that bylaws relevant to a criminal proceeding that have not been published as provided by paragraph D can be judicially noticed unless, so we have a mandatory with a but clause, and the but clause says unless the court is satisfied that proof of any of them should be made in the ordinary manner. Now, given the fact, as I point out in the paper, that bylaws are notoriously unconsolidated and notoriously hard to find, that some of the comments which Mr. Justice O'Hearn makes in the McLean case will be very apposite. The section or subsection 18E goes on to talk about that proof will be made in the ordinary manner, and I can only assume that that means the certified copies procedure which is found in section 150 of this Uniform Evidence Bill. And I also refer to the comparable Canadian and Ontario legislation. Okay, well that's the end of the mandatory. So what we have there is we have the statutes of Canada, the provinces, previous colonies, United Kingdom, and then all the regulations and other forms of subordinate legislation. Then we come to the discretionary ones, and I suppose what's a little surprising about the discretionary ones is the exclusions or the omissions rather than the commissions to paper here. For instance, foreign law is excluded, and that is covered by Section 177, and that foreign law shall be treated as a question of fact by Section 177. So that is not included. The question, the meaning of the phrase question of fact worries me, but we haven't got time to go into that today. Then the next item is that they have left out international law and treaties. And the task force explained that they thought that was unnecessary because it formed part of the domestic law of the country. And so they didn't have to specifically put that in, and they may well be right on that. Then there's 19A says the following, that the courts may, discretionary, take judicial notice of decisional law. Now that comes as a bit of a shock, you might think, that they may take judicial notice of decisional law. But they mean it in a very, very narrow sense. And I point that out on page 8 of the paper. The task force report gives an example that the decisional law they're thinking of is decisional law which would otherwise be required to be proved as a fact. And so they say the following, the task force report. The distinction here is between law as law to be applied in making a disposition of a case at hand, and law as fact, which is an element which must be established before the result of the case can be determined according to law. Then we come to the difficult bits. The difficult bits are the discretionary bits found in 19B and C. But before I get to the difficult bits in the paper, starting at page 8 and going on to page 9, I refer to the procedures. And you'll notice that in section 20, it points out that the court shall afford parties the opportunity to produce argument as to whether judicial notice should be taken or not. And after that has been done, 21 makes it clear, or does it, that judicially noticed data, we can hardly call it evidence, judicially noticed data or matter is conclusive. It is not subject to further disputation. In that respect, of course, they're following the Morgan theory of judicial notice, which is talked about in the uniform paper, background paper, and is also talked about here. The only thing that I find a little surprising is I do not know what it means when it says it will be conclusive. This is looking at 21.1. It'll be conclusive, but the court may change its mind where it's satisfied that judicial notice was based on error. Whether that means judicial notice at the present trial or judicial notice in the past, I'm not at all sure. But I would have thought that conclusive and based on error are mutually exclusive. Okay, on pages 11 and 12, I look into the question of what does it mean that 21 talks about judicial notice matter being conclusive. And you see there the remarks of Morgan, who wrote the famous article on the topic. Morgan, in his paper, uses words like notorious and indisputable. And I'm sure I'm nitpicking, but I noticed that those words, which have always been words to describe judicial notice, are not included in 19B and C. And perhaps I've spent too much time in the last couple of years with statutory interpretation, but I do find that the words generally known and cannot reasonably be questioned, which are in 19B, are somewhat different from notorious and indisputable. The indisputable question, of course, may be answered by 19C, which talks about facts capable of accurate and ready determination, but I'll come to that in a minute. Okay, well, that's pretty well the end of the provisions, and I do want to just spend a minute or two with you talking about the fact that the drafters of this bill and the uniform document looked at the question of should they include what Kenneth Culp Davis always called legislative facts. They have definitely included adjudicative facts, the facts which are in issue as potential evidentiary questions, and they are certainly covered by 19B and C. But they decided not to include legislative facts. Well, one of the reasons for not including legislative facts, I think, are the fact that it's a very stupid phrase, that it would be much better, I suggest, to call it policy facts. But the background paper says that they decided not to look at legislative facts and to include them in this legislation because they said it relates not so much to facts that have to be proven as to the mental context in which the judge views the case. Legislative facts may be thought of as social facts which constitute the fund of knowledge the judge has and upon which he must draw in determining the case. And so I spend some time on what I would almost call an anthropological issue, and that is the fact that American judges have a tendency to give their real reasons for judgments, or at least more than English judges and perhaps more than Canadian judges. And that a good argument could be made that if a Canadian judge is not going to give his real reasons, then you could make an argument for putting legislative facts in. And I know, Mr. Chairman, we're very short of time, and I will try and make this as short as possible. For instance, on page 17, I point out that there's an awful lot of data which clearly comes within 19C, facts capable of accurate and ready determination. And yet we know that those sorts of facts are very, very flexible given time, judges' particular predilections, and changes in usage and manners. For instance, the ones I point out on page 17 is the fact that no one has any problem with a judge looking at an almanac to look at the tides or the phases of the moon or the time of sunrise, or looking at a table of measurement to show how long this is or that is, or how many pints there are in a gallon, or what have you. But I do point out that fashions in terms of facts which are accurate and not subject to dispute have very much changed. I remind you, for instance, of blood tests and paternity suits as one that Charles Chaplin would remember very carefully, well, if he were alive today. I also point out I suppose the pioneer case of Ostrovsky about breathalyzers, that they've certainly changed their views about breathalyzers. Another one mentioned here is radar traps, whether such information should be automatically accepted. And of course, it hasn't been automatically accepted for the reason that counsel have disputed on the basis of what wouldn't be Section 20 here. So I don't really have any great trouble with what I'd call sort of tombstone accurate information. And on page 18, I mention a few of these, that a pint is less than 5 gallons. That's pretty obvious. Money's changed its values between 1189 and 1868. I would think that's fairly obvious. Then we start to get into slightly foggier areas, that some forms of mental illness are hereditary. I would have thought that's very much subject to academic fashion. The facts of venereal disease, whatever they mean by that. The question of how the telephone works. Judges may well accept judicial notice of how a telephone works, but they wouldn't feel the same, say, about computers. And then I couldn't resist the last one, where a court made or took judicial notice of how the postal system worked, and the case is called Warren versus Warren, which was very appropriate.